go on and set this up. All right, so let me introduce myself first. I can hear this now. My name is Alex Cloud. I work for Park Ziegler here in Virginia Beach. I've been there for 2 years. Before that, I was a prosecutor for 6 years. This topic today, so this is the Young Lawyers Conference of the State Bar's Professional Development Conference. Given that it's the Young Lawyers Conference, I chose to focus on sort of very basic nuts and bolts approach for the young lawyers in the room. Even if you're not a young lawyer, hopefully you do not have extensive experience with sanctions, so I thought a nuts and bolts CLE would be useful. So that is the introduction and the disclaimer. Furthermore, this CLE is going to focus on conduct during litigation. So it's not going to focus as much on how you have to advise your clients. It's not going to focus as much on what you do in appeals. It's going to focus on what happens at trial, and more specifically a civil trial. So there are some civil discovery rules later on, Part 4 of the Rules of Procedure. I did not cover Part 3A for the criminal practitioners in the room. However, the sanctions provisions are relatively similar, and the code section 8.01-271.1 applies to both. So keep that in mind. All right. So the statutes we're going to cover and the rules of ethics, obviously, so we can get those ethics CLE credits, all happen in Rule 3. So Rule 3.1 deals with meritorious claims and contentions. Rule 3.3 is candor toward the tribunal. 3.4 is fairness to opposing counsel. Don't burn up the evidence, cook the books, anything like that. You heard me mention code section 8.01-271.1. The title is somewhat deceptive. It has to do with signing of pleadings and motions. However, as we'll find out later on, a signature implicitly certifies several things, and if you run afoul of that, you can get into some serious trouble. And last but not least, Rules 4.1G and 4:12 for the civil practitioners in the room have to deal with discovery. So we're going to launch in with Rule 3.1. Here it is. A lawyer shall not bring or defend a proceeding or assert or controvert an issue therein unless there is a basis for doing so that is not frivolous, which includes a good faith argument for an extension, modification, reversal of existing law. A lawyer for the defendant in a criminal proceeding or the respondent in a proceeding that results in incarceration may nevertheless defend a proceeding so as to require that every element of the case should be established. So there are two requirements going on here. The second one focuses a little bit more on criminal, but the first one, in essence, if I had a pointer, okay, I do have a pointer. I'm going to highlight the words, good faith. So unless there's a basis for doing so. Do you have a good faith basis of law and a good faith basis in fact for asserting what is in your pleading? Now, this should seem fairly common sense. We're going to get into some hypotheticals later on that deal with, do you have a good faith basis for arguing what you're arguing? But in essence, you need to make sure that your facts are correct, or at least that you have a good faith basis for believing they're correct. And then you need to make sure that the legal positions that you stake out are well researched and are backed by either existing law or, and this is a three-part secondary requirement, a good faith argument for extending, modifying, or reversing existing law. So we've all heard of the Levin case. We've heard of the Obergefell decisions. Those are all reversals of existing law. So obviously you can argue for a reversal, but it has to be one made in good faith. So you're not bound in shackles by what the law is, but you are bound by how our system works in terms of relying on stare decisis and other new codes and statutes. The second sentence has to do with criminal law. So I'm not going to focus on it as much. However, I believe that you can read into this section that if your client has told you he's guilty, which is an if, I understand that does not always happen, but if he has, that does not give you a good faith basis in fact or law to stand in front of a court and say, Your Honor, my client is innocent. If he's told you he's guilty, if he's told you he did it, if you actually accept the factual premise that he's guilty. You can't argue that he's innocent. However, you can make the other side prove their case all day long. Some people would think this might be splitting hairs. I don't think it's splitting hairs at all. That is two entirely different forms of argument. Judge, they haven't proved their case versus arguing a point that you know to be false. Now, if your client tells you he's innocent, he didn't do it, it changes the whole ball game. But assuming he tells you or she that they are guilty, ethically that constrains you a little bit because you're not able to take a position that you know to be false. That would be lying to a court, and you can't do that. Mercilessly, since it's Friday afternoon, 2:11, this rule only has 2 comments. So comment 1, you obviously have a duty to know procedure and use procedure to the full benefit of your client. So if you don't know a procedure, you can't use it quite as well. But you have to use that for your client. The law, procedural, and substantive establish. So the law and procedure establish limits and bounds under which you must act. However, knowing those bounds, you have to use them to your advantage. This statement next, however, the law is not always clear and is never static. So accordingly, in determining the proper scope of advocacy, account must be taken of the law's ambiguities and potential for change. So you can't take a position that you know isn't backed by existing law, but law always changes. So when we get into the cases in a bit, we'll see how those two standards interact with each other in producing a body of sanctions law that can be maddening at times. So, as I said previously, a good faith argument for modifying or extending existing law. That's the crux of everything we will discuss today. Can you assert this in good faith? Do you have a legitimate reason to believe the facts that you're saying? Are you relying on an expert witness report? Are you relying on what your client told you? Did your client tell you he's lying? Are you relying on a video? Do you have something that you can point to and say, this is why I'm taking the position I'm taking, or is it purely speculative? Because those are two different things. As you will see in a bit, the good faith argument, good faith standard is also codified. It's also in Rule 4:12 and 4:1. So this good faith argument, good faith standard runs throughout all of our rules. Okay, comment 2. And this will define, especially in a civil case, how far you can push your case. So the filing of an action or defense or similar action taken for a client is not frivolous merely because the facts have not been fully substantiated or because the lawyer expects to develop vital evidence only by discovery. The action isn't frivolous even though the lawyer believes the client's position ultimately won't prevail. The action is frivolous if, however, the client desires to have the action taken primarily for the purpose of harassing, maliciously injuring a person, or if the lawyer is unable to make a good faith argument on the merits of the action taken, or support it by that modification, extension, or reversal of existing law. So, question anyone in the gallery can take. Can you file an action that you think might not win? Do we have any prosecutors in the room left? I knew we had one. No? Okay. So Canvas versus Considine is a case that bears particular relevance on this issue. The facts in Canvas, it'll pop up later, but I'll discuss it now. Canvas involved a case where one lawyer a party sued another party. It was a legitimate cause of action. It actually survived 2 rounds of demurrers. Okay, so this is not, we've cooked up some bizarre cause of action. There was something in dispute. It survived not 1 but 2 demurrers. However, in the Canvas case, you had the pro se party admit in open court that they didn't actually file the action mainly to recover what was due to them, but they filed it to frighten the other party, to intimidate them, or to harass them. So in Canvas, you have a sanctions award against that party and ultimately the dismissal of the case. So keep that in mind. And this is, of course, a gray line when you have a client that really wants to move on an action, but where you think their motives may be improper. So a prudent attorney should always investigate. You have a duty to make a good faith inquiry as to whether or not the client's motives are pure. So this means even if a client brings you a ready-to-go case that is not frivolous, that stands on all fours with the law, if they're bringing it to harangue somebody, you have to take a step back and say, well, hold on, what are your motives here? Or if your client wants you to continue the case for the 6th time, merely to delay the case again, that's another instance where you have an improper motive. So the law here doesn't just take into account whether or not your case is on all fours with the law, also takes into account your motive. And the Elio 1445 also essentially held that. So I went through and broke out most of the Elios that related to these. They told me I had to go for 2 hours on a Friday. Elios are very important. You should know them. There will be multimedia later in the presentation, so hopefully that will keep you awake. But so Elio 224, it's not improper for you to appeal a holding even when the filing of the appeal defeats the purposes of the original judgment. I think this law sort of flows from having the right to appeal in the first place. So as long as your appeal has merit, you can do it. Now, what does your appeal having merit mean? Well, first, you have to have standing. If you don't have standing, you can't appeal. So if you appeal without standing, someone will probably try and sanction you. Number 2, is the law and the argument that you're putting forward meritorious? Can you back it up under the existing law? Can you argue that an extension of law should be made? On the criminal side of things, this is actually covered by what's called an Anders brief, which is when your client tells you you shall appeal. You don't think that there is a good faith basis for appealing, so you file a special type of brief to comport with your ethical obligations to appeal. I know it's not in the outline, but that is something that comes across in criminal practice. But in other words, the good faith standard should motivate you if you're filing the appeal. Okay. So Elio 1224. How many people practice criminal law here in Virginia Beach? Okay. And what's your name? Okay, Jennifer. Does the General District Court have a sentence that it often gives out for first offenders? And does it have sort of a procedure and practice for dealing with when certain facts come up in the DUI? Okay. This LEO is of somewhat similar nature, but let's say you have a court that deals with a fact pattern in a very similar way. So if you, and I used to work in a jurisdiction where this came up 5 years ago, so I don't really remember it as well. But essentially, if you're asserting a cause of action in a jurisdiction and that cause of action on the same facts had been previously dismissed by this court, LEO 1224 essentially says, look, you can file your cause of action. In fact, you can even not have to tell the court of the same action or type of action's failure, as long as you can make a good faith modification or reversal of existing law. Now, there's a caveat to that. You don't have to tell the court about the prior adverse decision. I do remember now, it has to do with the helmet statute, the statute requiring you to wear a helmet. So that's been held to be unconstitutional. The officers would still charge it, but then the defense bar would come in and present the case and it would get kicked. But so sort of that situation, is it ethical for the situation that came up, is it ethical for us to advise them to charge it? And actually we had to say no because of the controlling legal authority, but they still charged it anyways. So, however, this opinion says you don't have to disclose the adverse law. Rule 3.3, if it's published authority by the Court of Appeals or by the Supreme Court, you actually do have to disclose it. It's adverse authority, you know about it, you need to let the court know about it, and then try to distinguish it. But LEO 224 and 1224 give litigants a fairly broad latitude to bring claims, so long as they're backed up by good faith facts and a good faith argument, at least for the extension or reversal of existing law that supports your position. In the Gilmore case, which we will get to, we'll discuss that in depth. Also had an extra wrinkle because Mr. Gilmore was acting as the governor and he has an enhanced duty to act. Okay, this is a statute of limitations, LEO. Essentially, you can file a cause of action even if your statute is already run. This is fairly rote. For civil practitioners, for prosecutors, obviously you don't want to bring an action after the statute is run. You're going to run afoul with different issues. But for civil practitioners, you have a personal injury, you waited 2 years and 5 days to file, you can still file it. Because statute of limitations is an affirmative defense, so the other side has to plead it. I don't know what other side wouldn't plead it. They might not, though, so you can still file. Okay. So Elio 1327, somewhat fact-specific, but in essence what happened in this legal ethics opinion is someone filed for a default judgment against a debtor who had already listed the debt in a bankruptcy case. So basically don't do that. If you know they've listed the debt, you therefore cannot turn around and file on it because you know or should know anyways that the bankruptcy court has jurisdiction over that and is going to pun it. Okay. Elio 1736. Now this says a lawyer can threaten appropriate legal action against a non-party witness for defamation of the lawyer's client. The lawyer has a well-founded belief that the threatened legal action is warranted. However, you can't engage in that tactic if the legal action is without legal basis in law or fact, and the suit is made with the intent to harass. So the fact pattern in this case, and this Elio is worth a read. I believe this is the Fair Housing Act case. One set of parties was evicted from the house. They made a claim against the other party for violating the Fair Housing Act, and the cross-party in turn threatened one of their witnesses with a defamation lawsuit. And what was going on in this case is the evicted parties were saying that they were being racially discriminated against. The landlord turned around and said, no, you're defaming me. So this LEO addresses, is that conduct ethical? And the answer is, if you're just making the counter accusation to harass and bully these people who are against you for making a potentially valid legal claim, then you've crossed the line, you've broken the rules of ethics, and you should probably be sanctioned. However, if you have a well-founded belief in fact is important here, and law, you can go on and make that counter-accusation. That would then become another counterclaim to their cross-claim. However, you would have to sit down with your client. You would have to talk to your client and have, on the basis of a good faith inquiry, the belief that they are indeed factually correct before you can make this accusation. If you don't investigate it, you could potentially run afoul of the rules. Even if it's true, if you fail to investigate, I believe you are putting yourself at risk. Okay. So LEO 1214. And this has to do with accusing the other attorney of doing something improperly. In this fact pattern, you had, I believe, one attorney accusing many different litigants of unethical and illegal behavior. They would do it in pleadings, but they would never report it to the bar. This LEO held, if another attorney is impugning of their opposing party's integrity and competence, it's undertaken only to harass or cause malicious injury, that's improper. In other words, you can't falsely accuse someone of breaking the rules. If you are going to make a motion for sanctions or accuse someone of being unethical, you had better do a good faith investigation. You should have a good faith basis in fact for backing up your claim before you make that claim against them. And specifically in this case, they dealt with two separate ethical rules here, the threat of a civil suit and a civil action, which does not violate Rule 3.4 because it's not a criminal or ethical charge. But you also had this at the bottom. The committee also held that the loud and offensive manner of accusations should not be done, but did not comport with the existed and suggested standards of conduct. I bring that up because we have published case law that we will discuss in a bit. Williams and Connolly actually was one of the parties, so those of you watching in Northern Virginia should take note. They used, the bar relied on disparaging comments made, actually directed at a judge to uphold a sanctions award. So while this Elio says loud, offensive, hyperbolic accusations shouldn't be done because they don't violate professional conduct, I would caution anyone from doing that beyond a professional level, but more so, that could very well be used as evidence against you in a disciplinary proceeding. And it can infer evidence that you only intend to harass the other party. So that's why you certainly would want to avoid that. Okay, Elio 1495. This has to do with issuing subpoenas ducis tecums, and essentially, if you can't issue a pleading that you know is not enforceable. This also comes up in criminal practice. If you're a prosecutor, if you're issuing an out-of-state witness that doesn't follow the Uniform Out-of-State Witness Service Act, be leery of that, because you can't issue a court document or a court order knowing it's not enforceable. So this LEO, they issued a subpoena ducis tecum on an out-of-state resident. They knew it was unenforceable when they did it. So this was not, oh, we're going to serve your corporate agent, have them accept service. It's a private resident. We know we can't enforce it. We've issued it. This is, in essence, what a frivolous pleading is. You knew it wasn't enforceable. You issued it anyways. You've broken the rules.